Hello everybody, I'm Massimo Bartoli from ECIPA Umbria and welcome to this brief presentation on the theme of social enterprise, of the connection between social enterprise and the European legal framework on state aid and new possibility of financing for social enterprise. We hope to be not too boring. What is the S factor in the European Union's most recent growth strategies? It's the link between social and ethical principles with work, consumption, savings, as we can read, for example, in the 2011 communication from European Commission number 682. Or for example, in the European Growth Strategy Europe 2020, which has one of its focal points on the connection between social issues with economy and innovation in order to find new way of struggle against social exclusion and poverty. So the natural recipient of this kind of policy is the social enterprise itself. A substantial reality, as we'll see, that often constitutes one of the preferred choice for female entrepreneurship. There are typical features of the social enterprise. The European Commission does not claim to offer an exhaustive definition of this kind of undertaking, but only a description found on common principle that we can find in various member states. What it appears immediately relevant from the legal point of view is the definition of enterprise or undertaking. For the European Union primary law and the jurisprudence of the Court of Justice of the European law, only the competition rules, in particular those connected with the state aid issue, are applicable only to undertakings or enterprises. This concept covers any entity which exercises an economic activity that in the European Union law can be defined as any activity consisting in offering services and goods in a given market. Even if the social enterprise can be defined as social economy actor, or it's clear that its habitat is the internal market, and so all the competition law can be applicable to the social enterprise. Let's see the common feature of the social enterprise. First of all, the social enterprise has its primary objective in achieving a social impact, a social return, rather than generating profit or benefit for owners and shareholders. We can say that it's more oriented towards stakeholders than shareholders. This social impact, the social return must be measurable, for example, with and connotated with an high social efficiency, and also its method. The method of production, goods and services are themselves capable of incorporating this social objective. These enterprises are mainly reinvested to achieve social goals, and there must be also predefined procedures and rules covering any distribution of profits to guarantee that such distribution does not undermine the primary objective of a social enterprise. The same method of management must reflect the aforementioned social objective, must be accountable, transparent and innovative. On this basis, for example, the praxis has found two typical business streams in the social sector: the enterprises that provides services and goods that can be defined social, for example, access to housing, healthcare, or assistance for elderly or disabled persons, or services that or goods that are not themselves can be defined social, but they pursue social objective. For example, we can think to, for example, training for social employment. We say that the social enterprise is a substantial reality. Let's see some facts and numbers. In the European Union, there are 11 million of people employed in the social sector, assuring the 6% of total employment. Approximately 1 in 4 businesses or enterprises are social enterprises, and this relationship can rise to 1 to 3 in Belgium, Finland and France. And from the qualitative point of view, the social enterprises usually are really productive and competitive, with a high level of employee personal commitment and better working conditions. In addition to the social business initiative of the European Commission, there are also other tools for the social enterprise, such as, for instance, the tools linked with the European Commission communication on corporate social responsibility, and the instruments linked to Small Business Act. The Social Business Initiative was launched in 2011 with a communication with the aforementioned communication number 682, and it aims a triple objective in order to improve the ground for social enterprise, improving their possibility of access to finance, to give them more visibility, and to optimize the legal environment. The whole plan embodies an emergence posed by peculiar issues that make it difficult to access to all the opportunities offered by the internal market. Of course, all the plan is directed to different structures of social enterprise. The small ones, whose activity is directed only at a local level, and the large ones, which aims to conduct a cross-border activity. Slide number 5 shows the 11 key actions to be launched before the end of 2012. What has been accomplished, for example, for the access to finance actions? There are two possibilities from the European law offered to social enterprise: to access to public resources or to access to private funding. From the side to access the public resources, the regulation 1296 has the merit to have enclosed in a single set 3 complementary priorities of European Union social innovation strategies. In fact, the program consists in the progress axis, oriented to support development, implementation, monitoring and evaluation of specific European tools. The EURES axis, designed to promote among the circuit voluntary mobility for workers interested in a social enterprise, and the microfinance and social entrepreneurship axis. The third axis of the ESI program is the microfinance and social entrepreneurship axis. Its aim is to increase the possibility of access to financing for physical and legal persons. For physical person, we have to think, for instance, to unemployed or people at risk of unemployment, people with difficulties in entering or re-entering in the labor circuit, and or people who are socially excluded, people with difficulties to access to the traditional credit market. In particular, people who want to start or develop their own micro-enterprise. The legal persons are substantially the micro-enterprise in both startup and development phase, with, for example, the same micro-enterprise who intend to occupy the aforementioned category of persons. For this third axis, in accordance with Article 25 of the aforementioned regulation, the financial allocation are divided into microfinance for vulnerable groups and micro-enterprises at one side, and on the other side for a specific financial allocation for social entrepreneurship for the minimum percentage of 35%. The remaining part may be assigned to both or to a combination of them. The same axis also proposes the development of the institutional capacity of microcredit providers, as well as the support of social investment market and the access to credit for social enterprise. Just to benefit of social entrepreneurship, there are made available forms of supports such as equity, quasi-equity, loan instruments and grants up to 500,000 euros for enterprise with either an annual revenue not exceeding 30 million euros and or annual balance sheet total not exceeding 30 million euros, the same, as long there is only one condition: they must not be collective investment undertakings. The beneficiaries of these financial measures are public and private bodies operating at national, regional or local level that are already carrying out such activities. These activities must be coordinated with the European Union cohesion policy and the possibility offered by structural funds. We know, for example, the new possibility offered by the European Social Fund for Social Enterprises. On the stimulus to project funding, the European Union has created new and specific financial instruments like common investment funds, which are specialized in the social area, following the key action number 3 of the Social Business Initiative. These instruments, this acts, has been adopted on the legal basis of Article 114 of the Treaty on the Functioning of the European Union in order to approximate, to uniform the European instruments on this area. European regulation on HILTIF, which are long-term investment funds, and regulation on EUVICA, which are venture capital funds, can interest the social enterprise area. But the typical instruments is the regulation 346 on European Social Entrepreneurship Funds, that is a direct implementation tool of the Social Business Initiative. It's tried to establish a common framework of rules regarding the use of a typical European designation, EUSEF. This designation tries to qualify social entrepreneurship funds. In particular, the managers of this fund can apply any method by which the exposure of the fund can be increased beyond the level of the committed capital. They can risk and they should assure A positive social impact, for example, in the qualifying portfolio undertakings in which they have invested, while apply a high level of diligence in the selection and in the monitoring of the investments. Finally, should be reported a recent European Commission initiative on the field of education and dissemination of social enterprise culture. There is a special guide, a recent special guide, which contains both operational proposal that survives of good practices, intending to stimulate, also in terms of creativity, the search for innovative solutions to financing, which all the external contributions should not alter the mission or the peculiarities of such companies, and also outlining the contour of an ideal social finance ecosystem. Let's see the stated notion. We have said that all the competition norms from European Union apply to undertakings which exercise an economic activity. A stated notion has been refined by a comprehensive process from European Union, that is the state aid modernization process. These are some news for especially for enterprise which provide social services or services that do not affect trade between member states. For state aid, we mean all public facilitation with a specific transfer of resources to few companies, causing an undue advantage to distort intra-European competition. This facility must not be only or necessarily take the form of a grant, being able to manifest itself in many different ways, from tax benefit to capital guarantee. Article 107 of the Treaty on the Functioning of the European Union states the prohibition of granting public aid to companies that could threaten, also at potential level, the mechanism of free competition. This prohibition must be considered as relative, because it's tempered by specific compatibility exception. Some of them are provided by the treaty itself. You have to think, for example, of particular beneficiaries or particular circumstances in which aids are really required. Others can be declared compatible by the European Commission discretionary authorization, and only in one case by the Council. The Treaty on the Functioning of the European Union doesn't offer an exhaustive definition of what state aid is. So its elements have been gradually outlined by the analysis system predisposed by the European Commission and the European Court of Justice within their respective rules. This has led to the consolidation to a particular criterion, the IST criterion, whose acronym indicates in order the necessary coexistence of the following structural elements: the economic advantage for the recipient company, the incidence or the impact of the measure in the intra-European Union market, the selectivity of the measure in the sense that the aid is designed to favor only a few companies and not all of them, and the transfer of public resources. An additional parameter, the fifth parameter, can be found in the size of the intervention, if higher than the economic threshold that determines the configurability of the minimum aid. The state aid notion is linked with the classic procedural method. According to the classic procedural method, the European Commission is the main actor of the European Union policy on AIDS, primarily through its permanent control function on existing aids, and then to the possibility that the European Executive is called to check. All new aids whose project must have been notified to its scrutiny. Remaining suspended, this is the standstill clause, until authorized by its decision, of course, if positive. The state aid modernization process provides, first of all, to clarify some key concepts of state aid law. For example, the real meaning of aid, the role of national judges, to provide a regulatory simplification, and to streamline the procedural process. One of the typical interventions in this third area is the provision of more and more exemption from prior notification tools, especially for horizontal aids, the aids that concern every sector. This exemption has a direct connection with the implementation of aids in loco by the licensing authority. Regarding key action number 11 of Social Business Initiative, we can see that something has been done on the field of services of general economic interest. The concept of service of general economic interest is typically a European concept. In the member states often prevail the notion of public service. Member states decided for a long time to regulate public service by entrusting the public monopolies or undertakings with special and exclusive rights, despite the presence in the founding treaty of Article 106, second paragraph, which explicitly mentions the notion of service of general economic interest. At the completion of the common market, the European Union decided that the time has come for scrutiny these national choices, because important sectors were open to the rules of competition and freedom of movement. So, the European Commission, the Court of Justice, were entrusted to scrutiny the legitimacy of state allocation of special and exclusive rights in favor of undertakings which were a sign of service of general interest, rights to compensate for public service obligation that these undertakings were required to comply. So, the monitoring of state activity could no longer avoid the evaluation of the appropriateness of such measures with the stated rules. The public services obligation must be created on the provider according to a specific entrustment act. This act must be provides the provision of service to the undertaken, specifying the nature of the task, the scope, and operating conditions. The European Union does not impose prescription in the formal national designation of a service of general economic interest. The member states are linked to the European ground only if the European Union secondary legislation has been created on this kind of services. Currently, there are, for example, the sectors of transport, gas, electricity, electronic communication, and postal and energy markets. On the issue of the relationship between service of general economic interest and state aid, the European debate has fluctuated over the years between two different criteria, the one of the aid and the one of the compensation. According to the first criterion, each allocated compensation for this kind of services may constitute a potential aid. According to the second criterion, the examination should instead be conducted only to cases of overcompensation. The European Union Court of Justice judgment Altmark, the year is 2003, consolidates the current orientation, that is, not to consider automatically the state facilitation as a direct counterpart to offset the public service obligation. This can only happen if four cumulative conditions coexist. Otherwise, the measure will be qualified on state aid. These conditions are the effectiveness, the presence of an act of entrustment, where the public service obligations are specified, the transparency. The parameters for calculating compensation must be established in an objective and transparent way. The proportionality. The compensation shall not exceed the coverage of public service obligation costs, taking into account the concerning revenue and a reasonable profit. The efficiency. The need of a public selection procedure to choose the operator. Otherwise, it will be necessary to determine the level of compensation on the basis of a cost analysis of a typical well-managed undertaking, in consideration of the proportionality parameter. In the field of service of general economic interest, the state discretion meets two limits. One, as we have already seen, is the necessity to take account of the sex of the sector, which have been already harmonized at the European Union level. Here, the margin of the national legislator can conflict, but possibly only expand and improve the contents of the European legislation. Also, there is the so-called manifest error of assessment, with respect to the control of which the Commission decision-making practice and the court's case law provide many examples. To mention the most frequent, we can think to the non-presence in the office service of a real economic interest, or the possibility that the public service is already provided by the private sector, and so the public compensation, the public contribution it's out of reason. Let's see the 2011 Almunia package, which have substituted the Monti Cruz package of 2005. The new package is in line with the overall objective of the state aid modernization, because it tries to ensure a diversified and proportionate approach to the various services of general economic interest, with the purpose of calibrate the aid examination on the real nature and extent of service provided, acting also on regulatory simplification for small-scale services, ensuring the respect of competition law in the cases of a cross-border impact. The tools of the Almunia package are the following. The European Commission Communication 9404 on the application of the European Union stated rules to compensation granted for the provision of services of general economic interest. Such a tool was not present in the previous package, and it only proposed a general classification on the basic definition, as the concept of aid, the concept of enterprise, the concept of economic activity. Also, the Almunia package contains two tools that are directed to different amount of aid. For aids under the amount of 15 millions of euros, there is the decision 9380. The spirit of this tool embodies the conviction that compensatory amounts for social service are not automatically synonymous of greater risk of distorting competition. Under this amount, the internal market is not disrupted. The general threshold provided by the decision 9380 is 5 million of euros, but under this amount there is no prior notification to the European Commission. But for social enterprise there is also another opportunity, in the sense that if these enterprises if their activity are directed towards social needs, health and long-term care, childcare, access to and reintegration into labor market, social housing and the care of social inclusion of vulnerable groups, the categories under Article 2, first paragraph, there is another special treatment, can receive a compensation superior to 15 million of euros. They receive the same treatment of hospitals, for example. The other instrument, the European Union framework, is adopted in a form of communication, is a tool for regulating cases of compensation which remain outside the meaning of the decision, in the sense that the compensation here exceed the threshold, the prior threshold, and so all the process remains subject to prior notification mechanism to the European Commission, and we are compelled to wait the European Commission scrutiny. The picture of a 2011 Almunia package is completed by a specific regulation on de minimis design aid designed for service of general economic interest. This tool offers two new opportunities to social enterprises. One of them is a superior threshold if compared with the one provided by the General de Minimis Regulation, which is Regulation 5,407. For service of general economic interest, the threshold is 500,000 euros. For general de minimis aid is 200,000 euros. Also, on the side of the rules of cumulation provided by these two different regulations, we can't cumulate different general de minimis aid. We must remain here under the threshold of 200,000 euros. But in the case we would like to cumulate aids for services of general economic interest and other de minimis aid, here we can remain in the superior threshold of 500,000 euros. Thank you for your attention. If you want, you can contact me directly at this email. See you.